On February 22, 1994, the Supreme Court of the United States declined to hear the appeal of a Texas death row inmate named Bruce Edwin Callens. Justice Harry Blackmun used the occasion to announce something he had been moving toward for years. He was done with capital punishment. He would no longer, as he put it, tinker with the machinery of death. In a lengthy statement, he argued that the death penalty as administered in America was irreparably broken, that the twin requirements of fairness and certainty could not be reconciled, that the system would always produce errors, and that errors in capital cases meant the execution of innocent people. Justice Antonin Scalia wrote a concurrence. He disagreed with Blackmun's conclusion, and he wanted to say why. He did not choose to argue about Bruce Callens, the man whose case was before them. He chose a different case, one pending on the court's docket, one he apparently believed would illustrate more vividly than Callens the kind of crime that made the death penalty not just permissible, but necessary. The case was McCollum versus North Carolina. Scalia described the crime in McCollum, the rape and murder of an 11-year-old girl. And then he wrote, "How enviable a quiet death by lethal injection compared with that." Henry Lee McCollum was sitting on death row in North Carolina when those words were published. He had been there since 1984. He was 29 years old. He had an IQ of approximately 60. He read at a second-grade level. He had been in prison since he was 19, convicted on the basis of a confession signed at 2 in the morning, after 5 hours of interrogation without an attorney. He had not raped or murdered Sabrina Bowie. He had nothing to do with her death. 20 years after Scalia cited his case as proof that the death penalty was sometimes not only just, but morally required DNA evidence established that another man had killed Sabrina Bowie, a man who had been sitting in a North Carolina prison for years, a man who had never been seriously investigated in 1983, a man whose existence in the case had simply not been pursued. Henry McCollum was exonerated in September 2014. Antonin Scalia died in February 2016. In the 2 years between those events, there is no public record of Scalia having mentioned Henry McCollum's name a second time. That is where this story begins. Not in Robeson County in 1983. At the Supreme Court in 1994, where a justice of extraordinary intelligence and legal conviction used the name of an innocent man to make an argument about the state's right to kill. Robeson County sits in the southeastern corner of North Carolina, in the flat coastal plain country where the land is low and wet, and the summers run long and hot. It is one of the poorest counties in the state, has been for as long as records exist. The population in 1983 was a mix of white, black, and Lumbee Native American residents, each community with its own institutions and its own relationship to a legal system that had not always treated them with equal care. Red Springs was a small town inside the county, a few thousand people, a tobacco and lumber economy. The kind of place where most people knew each other's families across several generations. It was not a place that attracted much attention from the outside world. It attracted attention in the fall of 1983, and it did not let go of that attention easily. Joe Freeman Britt was the district attorney of Robeson County. He was known beyond the county's borders, though not in ways that reflected well on the legal system he represented. Britt had obtained more death sentences than any other prosecutor in the United States, a distinction that had earned him a place in the Guinness Book of World Records, and a reputation in legal circles as someone who pursued the ultimate punishment with a frequency that raised questions about whether he was weighing justice or accumulating victories. He prosecuted Henry McCollum and Leon Brown. Henry McCollum was not from Red Springs. He was from New Jersey. He had come to Robeson County in the summer of 1983 to visit his mother and his younger half-brother, Leon Brown. He had been in the county for a few weeks when Sabrina Buey disappeared. He did not know her. He had no connection to her family or her neighborhood. He was 19 years old. He had grown up with intellectual disabilities that had made school difficult and formal learning slow. He had an IQ between 60 and 69, depending on the assessment, a number that corresponds to a significant limitation in abstract reasoning, language, comprehension, and the ability to understand complex social situations and their consequences. He was not by any clinical standard a person who could fully understand his rights in a police interrogation room or the implications of signing a document he could not read. These facts were known. They were documented. They did not protect him. On September 24, 1983, Sabrina Buey did not come home. She was 11 years old. She lived in Red Springs with her family. She had gone out in the afternoon and did not return by evening, and her father reported her missing, and the search that began that night found nothing until the following morning, when her body was discovered in a soybean field not far from her home. She had been raped. She had been beaten with sticks. She had been suffocated. The physical evidence at the scene included a cigarette butt and a beer can, items that, if tested, might have connected the crime to whoever had committed it. In 1983, the forensic technology to test that evidence did not exist. The cigarette butt and the beer can were collected and stored. Sabrina Buey was 11 years old. She had a family who reported her missing on the evening of September 24th and who received the worst possible news on September 25th. That is what she was, a child, a daughter, a person whose death was a specific and devastating loss to specific people who had loved her. I want to say that plainly before I say anything else, because what followed in the years after her death involved her name being used in ways she could not have anticipated, and could not have consented to used as an example in legal arguments, as evidence in political campaigns, as the kind of detail that gets quoted in opinions and briefs without the person it refers to ever being consulted. Sabrina Buey deserved better than what the legal system made of her death. So did Henry McCollum. These are not contradictory things to say. The day after her body was found, a 17-year-old high school student told police about a rumor she had heard at school. Henry McCollum, she said, was acting strange. She didn't know more than that. She had heard something. Henry was new in town and acted in ways people found odd. The oddness of someone with cognitive limitations navigating social situations without the tools that most people take for granted. That rumor was enough to bring Henry to the police station. He went voluntarily. He was cooperative. He did not know that he was walking into something that would take the next 31 years of his life. Think about what it means to be in that room. You are 19 years old. You have the reading ability of a second grader. You have spent your life struggling to understand things that other people seem to grasp, easily navigating a world that was not designed for the way your mind works. And now you are in a police station in a county you barely know, surrounded by men with authority being questioned about the worst crime in recent memory in that town. No lawyer was called. No one informed Henry of his right to have an attorney present before answering questions. No recording was made of anything that happened in the hours before the confession was produced. The interrogation began at approximately 9:30 in the evening on September 28th. It lasted past 1 in the morning of September 29th, More than 4 hours with no break, documented no representation present, no recording running. At 1:37 in the morning, Henry Lee McCollum signed 2 statements that had been written by the interrogating officers. The statements described the crime in detail. They implicated Leon Brown, his 15-year-old half-brother, who was waiting outside the building. Leon Brown was then questioned. He was 15. His IQ subsequently measured was in a similar range to his brother's. He also signed a confession. The confessions described details of the crime scene that only someone present could have known, or that someone who had been told those details by investigators could have incorporated into a statement. The defense attorneys who later examined the confessions noted that the specific details appeared in the texts that the officers had written, not in any recorded statement by the defendants themselves. Henry said years later that he had told them what they wanted to hear because he believed that if he just agreed with them, he would be allowed to go home. He did not go home. He did not go home for 31 years. The first trial in 1984 resulted in convictions for both brothers on charges of rape and murder. Both were sentenced to death. The North Carolina Supreme Court later vacated the convictions on procedural grounds and ordered a new trial. The second trial produced the same result for Henry McCollum again, convicted again, sentenced to death. Leon Brown, tried separately, was convicted of rape and sentenced to life in prison. The legal process that followed stretched across decades. Henry McCollum filed appeals. The appeals were denied. He filed more. Those were denied too. He learned to navigate the court system from his death row cell, learning slowly and painstakingly with the help of other inmates who could read more fluently than he could, how to construct legal arguments, how to file motions, how to keep the machinery of his case in motion when the machinery of the state wanted it to stop. There are not many ways to describe what 31 years on death row does to a person. The waiting is a specific kind of suffering, not the active suffering of physical pain, though that is present too in the conditions of long-term incarceration, but the suspended suffering of a person who does not know when or whether their life will end by state action. Every appeal that fails is both a continuation and a potential end. Every year that passes without execution is also a year closer to one. The uncertainty does not diminish with time. It accumulates. Henry McCollum spent those years in a system that had decided what he was and was not interested in reconsidering. He was the man who had signed the confession. He was the man whose case had been upheld on appeal. He was, in the language of the legal record, a convicted rapist and murderer awaiting execution. The system had no mechanism for seeing him as anything else, and the people in positions to change the record had no incentive to try. In 1994, while Henry McCollum was working through one of his appeals, Antonin Scalia wrote his name into a Supreme Court opinion. Scalia did not know Henry McCollum. He had not reviewed the evidence in the case. He had not read the trial record or the transcripts of the interrogations or the reports of the defense attorneys who had raised concerns about the circumstances under which the confessions were obtained. He had the bare facts of the crime as described in the case's certiorari petition, the age of the victim, the manner of her death, the participation of multiple defendants, and he chose those facts as his illustration of the kind of crime that made capital punishment not just defensible, but obviously correct. How enviable a quiet death by lethal injection compared with that! The sentence is rhetorically effective. It accomplishes in 11 words what a longer argument might take pages to achieve it. places the reader in the position of someone who has seen the worst of what human beings do to one another, and asks whether in the face of that leniency is the right response. It is the kind of sentence that works emotionally before it works intellectually, which is why it works at all. It is also a sentence that treats the conviction as established truth rather than as a conclusion reached by fallible human processes. Scalia was not arguing that McCollum was guilty. The conviction had been upheld, and Scalia had no reason to question it. He was using the crime to make a point about sentencing policy, but in using the crime, he was also using the conviction. He was lending the authority of the highest court in the country in print, in a permanent legal record, to the proposition that this particular man deserved to die for this particular act. Henry McCollum was on death row. He was intellectually disabled. He had no resources to speak of. He had signed a document that investigators called a confession. From where Scalia sat in the Marble Building on First Street in Washington, the case was not complicated. In 2010, 16 years after Scalia's opinion, the North Carolina Republican Party printed Henry McCollum's booking photograph on a campaign flyer. The flyer accused a Democratic candidate of being soft on crime and used McCollum's image as evidence of the kind of criminal that soft on crime policies produced. McCollum was still in prison. He had not been consulted. His face was a political instrument deployed in an election he could not vote in a state whose legal system had put him where he was. He remained there in that cell, having been used twice now, once by the Supreme Court and once by a political party to make arguments he was not present to contest and could not answer. In 2014, the North Carolina Innocence Inquiry Commission examined the case. The commission had been established in 2006, specifically to review claims of factual innocence, not claims of procedural error or legal technicality, but claims that someone in a North Carolina prison had simply not committed the crime for which they were imprisoned. It was and remains one of the only institutions of its kind in the United States. The investigation focused on the physical evidence that had been collected from the field where Sabrina Bouie's body was found in 1983. The cigarette butt, the beer can, items that had been stored for 30 years that the forensic science of 1983 could not analyze, but that the forensic science of 2014 could. The cigarette butt yielded DNA. The DNA did not match Henry McCollum. It did not match Leon Brown. It matched a man named Roscoe Artis. Roscoe Artis was already in a North Carolina prison. He had been convicted of the rape and murder of a young woman in Robeson County in October 1983, less than a month after Sabrina Bouie's death. The crime had been strikingly similar in method. A sexual assault, severe physical violence, a victim left in an isolated outdoor location. Artis had a history of violent offenses against women. He had been living in Red Springs in September 1983, in the same area where Sabrina Bouie had been killed. He had never been questioned in connection with her death. In the original investigation of 1983, the police had a rumor and 2 intellectually disabled teenagers who could be induced after hours of overnight interrogation to sign documents confessing to a crime. Roscoe Artis, a man with a documented history of similar violence living nearby whose DNA would ultimately be found at the scene, had not been a person of interest. The fingerprints on the beer can found at the scene did not match McCollum or Brown either. On September 2nd, 2014, a judge in Robeson County reviewed the evidence and vacated the convictions of both Henry McCollum and Leon Brown. Henry McCollum, 50 years old, walked out of the Lumberton Correctional Institution. He had been incarcerated since he was 19. He had never seen a smartphone. He had never used the internet. The world he walked into was 31 years removed from the world he had left. In the weeks after the exoneration, journalists asked Scalia's office for a response. They received none. In the months that followed, Scalia gave interviews and wrote opinions on other matters. His position on capital punishment did not change. He remained a vigorous defender of the state's right to execute convicted criminals. He died on February 13, 2016. In the approximately 17 months between Henry McCollum's exoneration and Scalia's death, there is no public record of Scalia having commented on the case that he had used 20 years earlier as a pillar of his argument for capital punishment. The officers who interrogated McCollum and Brown in 1983 were not criminally charged. The district attorney who prosecuted the case was not censured. The legal record of Robeson County does not reflect in any formal way an acknowledgement that the process which produced 2 death sentences had produced them through methods that made an accurate outcome nearly impossible. In 2023, a civil jury awarded Henry McCollum and Leon Brown $75 million in damages, finding that the officers who interrogated them had fabricated evidence, coerced confessions, and suppressed information about Roscoe Artis that was available at the time of the investigation. It was the largest wrongful conviction verdict in North Carolina history. Robeson County announced its intention to appeal. I want to try to say something precise about what the Scalia moment represents, because I think it is easy to misread it, to treat it as primarily a story about Scalia's personal culpability, which is not quite the point. Scalia wrote what he wrote because he looked at a legal record that showed a man convicted through proper procedure of an atrocious crime, and he used that record to make an argument about sentencing policy. He did not fabricate anything. He did not claim to know more than he did. He worked with what the system had produced and drew a conclusion the system invited him to draw. The problem is, what the system had produced a conviction built on a confession extracted from an intellectually disabled teenager who had been interrogated for hours without representation, who could not read the document he signed, who had told investigators he was telling them what they wanted to hear so he could go home. A confession taken in a room with no recording running by officers who had a specific suspect in mind before they began asking questions, who would later be found by a civil jury to have fabricated evidence and suppressed information about the man who actually committed the crime. Scalia used that conviction as a foundation for a national legal argument. He was not alone. The conviction had been upheld at multiple levels of the North Carolina courts. The system had approved it repeatedly. The wrongness moved upward through the levels of judicial review until it reached the highest court in the country and became, in Scalia's words, evidence that the death penalty was sometimes not just permissible, but morally obvious. That is the particular danger of a wrongful conviction that ascends through all the levels of a legal system without being caught. It does not just damage the person who was wrongfully convicted, though it damages that person enormously. It damages the reasoning that depends on the conviction. It becomes a brick in walls that should not have been built. And when the brick is finally identified as false, the walls do not automatically come down. They are already standing, already doing the work that was assigned to them. Scalia's opinion in Kalins versus Collins still stands in the official legal record. Henry McCollum's name is still in it. The sentence, "How enviable a quiet death by lethal injection compared with that is still there, indexed and searchable," attributed to an Associate Justice of the Supreme Court of the United States. It is part of the permanent architecture of American legal thought, and the fact that the case it referenced was built on coerced confessions and fabricated evidence does not automatically revise the architecture. That is what it means for an error to reach the top of a system before it is caught. The error becomes part of the system. The system continues to use it. The people who built the error, the officers who wrote the confessions, the prosecutor who brought the charges, the courts that upheld the convictions are insulated by the very fact that so many levels of review approved what they did. The approval is taken as validation. The validation makes the original error harder to see, and harder to admit, and harder to correct. Henry McCollum filed appeals for 31 years. The system denied them. The system was wrong for 31 years, and it required a cigarette butt in a storage room and DNA technology that did not exist in 1983 to prove it. Henry McCollum lives in North Carolina. He has said in interviews that he wants to live simply, that after 31 years, simplicity feels like abundance. He has described the experience of learning things that most adults his age have long taken for granted: how to use a computer, how to navigate a city, how to trust a world that treated him the way his world treated him. Leon Brown has said similar things. 15 years old when he signed that confession, 46 when he walked out. A significant portion of each man's life spent inside institutions for a crime that a cigarette butt and a beer can could have resolved in 1983 if anyone had thought to ask the right questions of the right person. Roscoe Artis is still in prison serving his life sentence for the 1983 murder that occurred a month after Sabrina Bouie's death. He has not been charged in connection with her case. He has denied involvement. The question of whether North Carolina will ever formally charge anyone for the murder of Sabrina Bouie remains open. The cigarette butt was always there. It was in the evidence storage for 30 years waiting. The technology to read what it contained did not exist in 1983, but the cigarette existed. Roscoe Artis existed. The pattern of his crimes existed. The investigators in 1983 had in their possession the physical object that would eventually establish the truth, and they did not pursue it because they had two teenagers in a room who would sign what they were given to sign. Justice Scalia wrote the name Henry McCollum into a Supreme Court opinion as an example of why the state should be trusted with the power to kill. 20 years later, the cigarette said otherwise. How enviable Scalia wrote a quiet death by lethal injection. Henry McCollum was 50 years old when he walked out of prison. He had time served to think about what enviable means.